I wanted to continue our discussion of perjury. Up to this point, we had been discussing perjury primarily in connection with the legal issue raised by the Seffer Davis case, which is whether there is a due process right not to be prosecuted with the knowing use of perjury and fabricated evidence by police and prosecutors. But perjury poses many more difficulties than that. It profoundly corrupts the process and impedes a proper investigation of the facts of a case. And I think the best way to sort of convey the impact of that is to explain to you the sequence of events from my point of view. Because when it comes to an objective investigation, I was the only one who did one. I first got the Seffer Davis matter in late June, early July of 2004. There had been about 4 attorneys involved in the matter before me, so there was a substantial file in the matter. And when I initially got the case, I approached the attorney immediately prior to me. He was a very good lawyer in Livingston County named Steve Sessler. And he provided the file and about a 45-minute phone briefing for me when I took over the case. At that point, you review the file, and there was a good deal of information in it. The important thing about what was in the file, about what had been produced through the interview with the client, is that from the standpoint of myself as the attorney, or even the 4 attorneys before me, that's also very important, whether Seffer Davis was driving the car during the robbery or not was not an issue. There was nothing that in the file or coming from Seffer Davis herself that indicated anything other than that she was driving the car. The only issue was whether she knew what was going on or not. This was not a set of facts from which it was going to be easy to argue that Seffer Davis was not guilty of at least knowingly participating in whatever crime had occurred, and there didn't seem to be any dispute that a crime had occurred either, in the nature of a robbery and kidnapping. Nevertheless, as the attorney representing the defendant in the matter, it is incumbent upon you to explore every avenue in which you might be able to argue that your client is innocent of a crime at a trial. An investigation proceeded. I began to interview other witnesses. I began to get, and it was very frustrating, I began to get information from just about anywhere I could that would shed light on any of the events in question. Between the period of July and October, when this matter went before the grand jury, I interviewed a number of witnesses, and as a result of what I was beginning to put together, I came up with a theory that there must have been another car and another female involved in the armed robbery that had taken place at 4 o'clock in the morning on December 9th of 2003. Then I figured the second car belonged to, and the second female involved, was a young lady named Mikkel Forko from Mount Morris, who I'll explain more about who she is and how that might have come about in a subsequent video. But in any case, this was a theory I had, that some other car had been involved with another female that had transported people back and forth, and that this was where the robbery had emanated from, and not from the car that Seffer was driving, her own car. And this theory I developed probably in late September or early October of 2004, just prior to going in to testify in front of the grand jury. It would be fair to say that I was never really comfortable with this because I had no direct evidence of it. It was all inference from essentially things my client was telling me, and piecing together other information that was already in the file. Because I was uncomfortable with it, I was very much open and kind of actively seeking any more information that might be better, that might enable me to come up with a better theory. One of the things that had been suggested during the previous 2 months on several occasions was that since the other 3 co-defendants were all serving their sentences, and the ringleader, the supposed ringleader of the group, Adrian Page, was serving his prison sentence just south of Mount Morris, so he was in the area, and the idea was that if I needed more information, that maybe I would go talk to him. But I hesitated to do it because I didn't really have any way to approach him that I thought might yield some reliable information. Now, for whatever reason, about a week before we went in to testify in front of the grand jury, I came up with an idea to approach Adrian. And the idea was that I knew that he lived at the time with his girlfriend, Angela, living with them, but in any event, they were a couple and they had a household. Angela had a car, but Adrian did not. And it occurred to me that I could approach Adrian and indicate to him that I suspected that there was a second car and a second female involved, and that I suspected it was Angela, even though I really suspected it was Mikkel. And that if I threatened to implicate Angela, that perhaps I could get some reliable information from Adrian, who would not want Angela implicated. So I knew who Adrian's attorney had been. I was familiar with him. His name was Tom Cacuzzi. Got permission from Tom to go see Adrian down in the prison, and I made arrangements on October 9th, 2004, and we were due to testify in front of the grand jury on October 13th, which is a Wednesday. So I went down to see Adrian on October 9th, and I went in to talk to him, and I basically implemented the plan I had come up with, and I threatened to implicate Angela. And Adrian immediately became very agitated about the idea that I might implicate his girlfriend, and then he said to me, "Look, you want the truth?" And I said, "Yes, Adrian, I need the truth. I need it right now." And the first thing he said to me was, Sephora was sick all day. And I said, "Well, what do you mean sick?" And he said, "Well, she was passed out. She was out of it." And I said, "What are you talking about? She was driving you guys around." And then he said, "No, she wasn't driving. I was driving." This was one of those moments where it's kind of hard to describe. From the time I had gotten the file in July until I had this meeting with Adrian in October, there had never been an issue about whether Sephora was driving the car or not. And all of a sudden, this was really the only issue there was. Was she driving the car, or was she passed out? Because if she was passed out and not driving the car, that would explain all kinds of other things that I had kind of found out in the meantime. But what was also very disturbing about this is that it would also contradict a lot of witness statements and documentary proof that had been provided from the district attorney's office through discovery, all to the effect that Sephora had been driving the car. So that interview with Adrian Page on October 9th, and I actually went back on October 11th, 2 days later, that was a Monday, in order to write it down as he told me, because the first time the prison officials would not let me take a pen and paper in with me. But those interviews of Adrian Page really changed the entire landscape of how this case had to be approached. And there wasn't really time in between the time I interviewed him and the time we had to appear in front of the grand jury to properly investigate all of the implications of what Adrian had told me, and especially the implication that there had been essentially an official conspiracy to commit perjury to implicate Sephora as the driver. But that was the secondary problem.